Hello and welcome to this webinar entitled Incorporating and Drafting Enforceable Terms in Consumer Contracts, an update with me, Keith Marker. As always, let's begin by having a look at the agenda for this session. So we're going to look at two major issues. First of all, the issue of incorporation of terms. So I'm sure we've all been faced with the issue whereby we visit a website, we've been faced with some sort of statement that says, tick here to accept the terms and conditions. Obviously, if you've ever looked at the terms and conditions, you will know that they can often be voluminous. Well, what does a trader have to do to make sure they have successfully incorporated those terms against you and me as individual consumers? Well, we'll see that most of the emphasis is around the meaning of the phrase reasonable steps. And we're going to see, that's our first topic today, how that was recently examined by the Court of Appeal in a case involving the National Lottery. Now, once we've incorporated those terms, the next thing that traders need to worry about, is whether those terms are fair or not. Unsurprisingly, if a term is unfair, it will be unenforceable against the consumer and therefore is of no value. However, if the term is fair, it can be enforced against the consumer. So we're going to have a look particularly at a variety of issues to do with that. We'll look at what we call the fairness test. We're going to have a look at the fact that there is an exemption called the core exemption. We're going to see requirements to do with transparency and prominence and various other things. We'll also look at where we can get further guidance from and so on. And then once we've done that, we will have a look at some recent case law. There's a very, very interesting case involving a couple of barristers who effectively wish to enforce their retainer with the client, and the client refuses to pay certain fees because they say that the term that the barristers are relying upon, demanding payment of those fees, is in fact unfair under the relevant regulations. And then finally, we will see if we do have a breach of these regulations since the 6th of October, the 6th of April 2025, the rules have changed to allow both the courts and the Competition and Markets Authority to levy fines of up to 10% of global group turnover for serious breaches of these rules and indeed other aspects of our consumer law.